Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. Just moments ago, a jury returned a verdict in the Pageant Queen child murder trial in Georgia.
The verdict reads as follows as to each count. On count one, it says, we, the jury, find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads, we, the jury, find the defendant guilty of felony murder, 2 counts, aggravated battery, 2 counts, and cruelty to child in the first degree.
Now, you just heard it. After nearly 3 hours of deliberations, the jury did find Trinity Poague not guilty of the top count of malice murder, but they found her guilty on the other 5 counts, including felony murder in the death of 18-month-old J.D. Williams.
And she had a very, as you saw, visible reaction. Well, right now, the sentencing phase is underway. Let's get inside that courtroom.
All right, we're going to address sentencing. Before we do that, I want to see if there's any disagreement as to merger of the charges or vacating any of the sentences because of the. I know that the aggravated battery charges merge with the felony murder charges, and I believe the cruelty to child does as well, but I want to see what both parties indicate.
No, sir, I don't think they agree.
Okay. What is your position on that?
The state's position is that, of course, the court could impose sentence on, that you go straight down the line. The court could impose sentence on count 2, which is felony murder. Count 3, felony murder, would be vacated because you can't be sentenced for 2 murders in the same case, okay, when there's only 1 victim. Count 4, aggravated battery, would merge with count 2, felony murder. Count 5, aggravated battery, would stand alone because you would only merge 1 felony with the felony murder, not 2. Even though the felony murder, because the felony murder is. Well,
can I see the indictment? Will you hand me up the indictment from the?
I mean, I have a copy of it. I don't know. I guess
it's with the exhibits.
Is it in that box?
Well, if you have a copy, that'd be just as fun. Well,
I just counted all the exhibits. I didn't even think about that.
I don't know. I do have.
You can hand it up. That's fine, Laura.
I do have a copy.
All right.
So
let the court reporter sit back there.
Yes, sir.
Huh?
Yeah, please.
All right, let me ask you this question. Felony murder in count 2 charges her with murder based upon the commission of aggravated battery by causing blunt force trauma to the head and torso, right?
Yes, sir. But that "and" is interpreted disjunctively, and I mean.
Let me finish my thought pattern,
yes,
and then
sir.
you can tell me your response to that.
Okay.
Count 4 charges her with aggravated battery by rendering his brain useless, and count 5 by rendering his liver useless. And then count 2, felony murder, charges him with aggravated battery for both of them. I mean, in either way, right? To the head or the torso. So why wouldn't both merge into count 2?
But first of all, with respect
Can
to...
we take a break? Are you looking for the indictment?
Yes, sir.
Okay. If it's not in there, then they need to hold everything in that. Okay. All right. All right. Okay, you can go ahead.
So, even though, which count is the count 2 is the one that relates to the aggravated batteries?
Yes.
Is that right?
Yes.
Okay. And so it refers to an aggravated battery based on damage or whatever to the brain and to the liver. That
head and torso.
Or head and torso, right? That "and" is should be interpreted disjunctively. In other words, if there was a finding that only a battery to the head, that would be sufficient to support a claim. A finding of guilty on felony murder. if there was a finding of aggravated battery only on the torso, that would be sufficient to support it. So since either of them will support the felony murder, only one of them merges. And then count.
How do I know which one merges?
First one. If you go straight down the list of charges, okay, and you get to, count 3 is vacated, count 4, merge with count 2, and then now there has been a merger for count 2, which means count 5 would not merge. It's left freestanding, and count 6 can't merge because count 3 was vacated. So the sentence should be on felony murder and on count 5 aggravated battery and count 6 cruelty to children. That is the state's position.
All right, Mr. Gamble.
Yeah, we disagree on that interpretation. I believe that the court is correct concerning the merger of the aggravated battery. That the only charge that should stand is the first count of felony murder, which is number 2. And then the others would have merged in one way or another and be out. And then the only other charge could be cruelty to children, I believe, would be the only one that remained with the felony murder. That's our position.
Do you happen to have any case law that addresses this particular situation?
Yes, sir. If the court wishes to take it.
Maybe we should take a recess.
Well, I'm looking right now, Judge.
Okay. And I did say, you do agree that then the felony murder, the 2 felony murders, 1 vacates, right?
Yes, sir. Count 3 is vacated. That's correct.
Okay. But the fact that count 6 would have merged with count 3 doesn't affect count 3?
No, sir. Once it's vacated, then there is nothing for it to merge with.
Okay. So the question is, and I think Mr. Gamble agreed with that, the question is whether count 4 and 5 merge with count 2, because the felony murder charge in count 2 included both, whether it's, I guess it says and, you say that says is the disjunctive, which means or,
right.
But it includes count 4 or 5 or 4 and 5. They could have found him guilty of both. Well, they did. They did find her guilty of both. So I guess I need case law on that. If the state is seeking a sentence on aggravated battery count 5. So we'll take 30 minutes. Mallory, you come with me, and we'll take it. I'll give you I'll alert you when I'm ready to address that.
All right, so what's at stake here? The judge, as he tries to decide whether he's going to sentence on that aggravated battery, that 1 remaining charge, and the cruelty to children. Well, that remaining aggravated battery charge carries 1 to 20 years.
Right.
And the cruelty to children carries 5 to 20. And again, the judge has to decide, does that aggravated battery merge into that felony murder, both of them, or does one of them survive? And while they take that recess to try to figure it out, they're going to get some case law and make their arguments. Let's bring in our guest, criminal defense attorney, former assistant prosecutor, Franz Burkhardt. Franz, great to see you. I am sure you've been in this position before. This comes up very often in these types of circumstances. Love to get your thoughts on it.
So if I'm defending her, I want to hit the brakes. I'm going to say to the judge, I want an opportunity to brief this. I want an opportunity for a full sentencing hearing to present mitigation. And I understand that there's some places in the world, in the United States, where sentencing happens immediately after conviction. I get that. But if I'm defending her, I want to hit the brakes. If I'm the prosecutor and I'm trying to max out her time, I might want time to actually brief this issue to show the judge that, look, yes, we threw a whole bunch of eggs into the basket of the indictment, but just because they convicted her of these things doesn't mean you lose the ability to enhance her sentence. And look, this whole entire conversation's about jail time. How much jail time is she going to get? How much jail time has she done? How much is she going to get? And what is the discretion the judge may or may not have with a mandatory minimum? So either side, I want to hit the brakes, and I want more time to inform the court.
You know what's interesting, Franz? The one reason I think if I were defense right now that I wouldn't hit the brakes is because the judge came out of the chutes doing what they want, which is saying they merge, it's felony murder, the aggravated cruelty to children, and now the judge is saying, is there any case law? So I think I'd see, is the judge still going to come down on my side? And if he is, then we don't need more time. But if he's not, then I'm going to say, wait, Judge, let's brief it. That's just my thought process. But part of this to me also, and I want you to weigh in as a defense attorney, Franz, it's not just the number of years and sentences. It's also, if there's an appeal, it's appealing 2 charges or 3 charges. And I would think that could be a significant difference. So
there's the appellate issues. And that's a big deal. That is a very big deal, especially if we're talking about different mandatory minimums. In Louisiana, you don't get this kitchen sink of she gets convicted of multiple types of murder and then we just kind of figure out afterwards. It's one. She gets one. And generally with felony murder in a lot of jurisdictions, you don't get convicted of the underlying felony and the murder. So there is that weird appellate issue that she has. And look, she's maintained her innocence. So it's not like she can stand up, Judge, and all of a sudden take responsibility, because at that point, what is she doing? The other side of this, though, is, and I understand it sure does look like the judge is leaning towards the defense, but that can change in a heartbeat. And man, oh man, would I want an opportunity to present some mitigation on her behalf.
That I agree with. And he set this sentencing, and to me, I guess I assumed they're not going to be witnesses because it is in local time 5 p.m. that on a Friday. And I would agree, and I'm surprised, Michael, that they didn't want to take the opportunity to present mitigating evidence.
Yeah, and again, I have to reiterate what's at stake here. If there are 2 additional charges, Franz, that she can be sentenced on, if he sentences her to 25 to life with possibility of parole, but she has consecutive sentences for, let's say, aggravated battery of another 10, because it was a very ugly and serious battery on a child in her care, and the cruelty to children, 5 to 20, let's say he hits her at 10 there. Now she's looking at being in jail for 40 years before she's available for parole. So I think this is very serious stuff for her.
So on the one hand, if you're the defense team, you're thinking to yourself, we just won this trial, because she's not been convicted of the most serious count, right? On the other hand, you're thinking and arguing everything should be run concurrent. This was one transaction. As horrible as it was, this was one act, one transaction, and you shouldn't piecemeal give consecutive time. That's the argument. Now, I'm not saying that is going to prevail in this case, Michael. I'm just saying that's the toolbox from the defense attorney. He or she is pulling out this should all be run concurrent. That said, I go back to what Judge was kind of intimating, which was, well, maybe he's leaning towards not giving her this big giant sentence and trying to give her, she's a young defendant. She probably doesn't have any kind of a criminal record. This is one where, as brutal as a murder as this was, there are mitigators to be argued, to be sure. And so, yeah, high stakes poker table right now. I'm sticking to my guns, though, guys. I would want time to put on a dog and pony show, so to speak, for sentencing, to put her in the best position to give this judge the tools to give her a better, quote unquote, sentence.
Yeah, fair enough. And I will say this, according to the law in Georgia, the only one really that's allowed to be put on consecutively, if it's not included in, is the cruelty to children.
Exactly.
He
Otherwise,
has the
it's
option.
concurrent.
He can sentence that separately, or it can be rolled in as a concurrent.
And those 2 stand. I don't think anyone disagrees. The felony murder, the aggravated cruelty to children, those 2 we know she'll be sentenced on. So what we're going to do is take a break. When we come back, we'll bring you more. We're going to continue to monitor the courtroom as we wait, because it gave a break for them to look at some law. And when it begins, we'll take you back to the Pageant Queen child murder trial sentencing of Trinity Poague.
But up next, we're going to turn back to Massachusetts to pick up testimony in the disappearance of Anna Walshe trial. So keep it here on your front row seat to justice.
Disappearance of Anna Walshe.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walshe murder trial. Live coverage today on Court TV.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. We bring you the latest surrounding the death of Anna Kepner.
Closing arguments tonight at 8, 7 Central, only on Court TV.
We want to head to Massachusetts in just a moment, but first, the court in Georgia is on a break to review case law ahead of sentencing for Trinity Poague. Now, the jury found her not guilty of the top count of malice murder, but found her guilty of all other charges. This includes 2 counts of felony murder, 2 counts of aggravated battery, and 1 count of aggravated cruelty to children. When they come back into that courtroom, we will bring you that sentencing.
Yes, we will, but right now we want to bring you testimony in the disappearance of Anna Walshe trial. Her husband, Brian Walshe, has pleaded guilty to charges of misleading police and improper conveyance of a body. Well, now a jury must decide if he's also guilty of killing his wife.
Anna was last seen on New Year's Eve in 2022 and was then reported missing by her company a few days later.
The state has focused on evidence about the defendant's Google searches, which included how long before a body starts to smell and can you be charged with murder without a body?
Let's head back to court now. The digital forensic examiner continues to testify cross-examination by the defense.
And those searches continue through 12:45:58 on page 4, don't they?
Yes.
Now, it's fair to say that once again, if you had the web history to that particular search, that would give more context into what that particular search is that you just talked about at number 54, record number 53 at page 4. It would give you more information and more context, would it not?
It would, yes.
You have no idea, do you, as you sit here today, what the user was thinking when he or she inputted that search that you just testified to, do you?
I do not. I know the content of it. I do not know the intent of it.
Okay. Are you aware of the fact, given the fact that you're an investigator, and I presume you conducted some investigation in this case on behalf of the Norfolk County District Attorney's Office, are you aware of the fact that Mrs. Anna Walshe, her flight was canceled on 12/25?
Yes.
And did you investigate the circumstances of that cancellation?
I personally did not.
Okay. So you're unaware of the snowstorm or anything like that that caused canceled flights?
I don't know the particulars around the...
All right. I want to focus your attention once again at Exhibit 161 to a number of searches that began at record number 445 at page 30.
Page 30, sir?
Page 30. And it's record number 445. Are you there?
Yes, sir.
Okay. It's fair to say, isn't it, that in looking at those entries starting at 445 and continuing through record number 495 on page 34, that they involve searches for what looks to be champagne or wine and varieties of champagnes and wines?
Do you mind if I take a look?
I don't mind at all. No, sir.
Okay. 445 through
495.
495. Sir, yes, that appears.
All right, as we brought you just moments ago, the verdict in the Pageant Queen child murder trial for Trinity Poague, the judge had sent the attorneys out to do some research regarding an issue regarding sentencing. My understanding is that they are now back in the courtroom, so we want to take you there live.
All right, I'm being told that the state and the defense agree that the sentence that the court is going to impose is for counts 2 and count 6.
Yes, sir. I advise Mr. Gamble that after doing some additional research, or some initial research rather, on that particular question, that I think that 4 and 5 would merge with count 2. And that being the case, the state's position is that the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct.
Yes, Your Honor.
Yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was, of course, there are very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will merge, will be vacated. Count 4 and 5 will merge with count 2, and count 6 is a standalone offense based upon the merger of count 3. The the fact that count 3 will have to be vacated. Is that correct?
Yes, sir.
All right. I'll hear from the state concerning sentencing as to count 2 and count 6. And of course, if you want to present any witnesses, you certainly can. And I believe the sentence possibilities are life on count 2 or life without parole. And on cruelty to children in the first degree, the sentencing range is 5 to 20. 5 to 20. Okay. All right. I'll hear from the state first.
None of the state proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2 with a sentence of 20 years consecutive on count 6. I understand that Ms. Poague is very young. I think this is the terrible tragedy of these kinds of cases. I have a baby as a victim, and who was at the time a teenager as the defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking, but I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill. And that would be the distinction between count 1 and the remaining counts. And so, in my view, if I accept that as a finding of fact, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, that there's evidence of conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if I do not believe that the evidence supported this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I feel constrained to leave the recommendation at life without parole. At life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to say anything from the family, or are you presenting any testimony?
No, sir. We're not presenting any testimony, and I'm not. The father of the child is not father and aunt are here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but we're not going to.
Okay. Mr. Gamble?
We recognize felony murder. I don't think if they're recommending life with parole, that's as lenient as the sentence could be under that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty to children, they're asking for consecutive 20 years. If you put that on there, you're coming very close to being life without parole, in that you will not come up for parole currently for 30 years and then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider, you've heard the evidence and you know generally what the whole circumstances were. She was 18 years old at the time, a young girl that had not had any trouble with the law, any problems, and was doing well. Now, obviously, she's accused of a horrendous crime that we fought about in court, but we accept the jury has made a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe that it would be akin to life without parole. And that would be what happens if you make this consecutive serving time sentence. So we would ask that on the cruelty to children that it run concurrent with the life sentence that she is going to be imposed on her for the felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge. Yeah.
All right, so there you heard the defense's argument. They're hoping that he brings that other charge and runs it concurrent rather than consecutive. Huge difference there.
A very big difference, and
Yeah.
I don't know what this judge is going to do. He pointed out, Judge, you heard the evidence, 18, no prior history.
Yeah, what does he think justice is for JD?
Yeah.
All right, we'll pause it right there. When we come back, the judge will be issuing his sentencing. Keep it right here on your front row seat to justice.
Welcome back to Court TV Live. I'm Judge Ashley Wilcox.
And I'm Michael Ayala. We are bringing you live coverage in the sentencing phase of the Pageant Queen child murder trial going on in Georgia. In a split verdict, the jury found her not guilty of malice murder or intentional murder, but guilty on the remaining 5 counts, including felony murder.
Let's get you back into court now. The judge is ready to issue a sentence. Very short arguments by counsel. He's going to tell us what his decision is.
All right, Ms. Poague, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case and I've, considered the tragedy on the left side, on my left side, and on the right side, and there's a lot of tragedy to go around here. The whole time that I'm hearing a case, I think about what the appropriate sentence would be. And this conduct all led, in my opinion, to the offense of felony murder. Even the charge that, would have merged with count 3, but does not because count 3 is vacated by count 2. That's a lot of technical jargon. But the bottom line is you're going to receive a sentence of life in prison, which is the appropriate sentence for the conduct that you have been convicted of. And that is going to essentially be the sentence that the court passes in this case. You will be sent on, so on count 2, I sentenced the defendant to serve life in prison. And on count 6, I sentenced the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Poague, that you have 30 days to appeal. You also have 4 years within which you could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy. And I hope that you can, in your older days, have some sort of life after serving this sentence. And life while you're in prison. I guess you just have to make the best of it. But that's the sentence of the court. I wish everybody the best.
All right, Michael. So he just decided it's life in prison, possibility of parole after 30 years. She'll be what, 48, 49 at that time. And these are going to run concurrent. We talked about that. What do you think?
I was surprised. I thought this type of crime, the fact that it was a helpless child within her care, that it warranted the consecutive sentence. But he said, I listened to the evidence. He's ultimately the judge, and he made this decision. I'm okay with it. 30 years behind bars is a very, very long time.